And we are back from recess. We want to welcome back our viewing public and my colleagues of the People's House. As part of our investigations into the expenditures of Governor Torres, we have questioned police officers, administrative personnel, and directors. And most of these witnesses have testified that they don't recall, they don't remember, they don't know, or have asked questions, simple questions, to be translated into the vernacular. All of them have brought legal counsel who have raised issues regarding procedures and language. On the other hand, we have had Lieutenant Governor Arnold Palacios and CUC Executive Director Gary Camacho, who willingly answered inquiries made by the members of this committee. Tadza impedimento durante i testimonio niya i Lieutenant Governor and i Director as Gary Camacho. Megay beses ni Inna Claruzzi zay nadingani i manmafatugini porofantistigo na ti Hamzo man maeemuk ti Hamzo man maimbistitiga. Tadza rason para todo este na impedimento. Laupago ni kakanto halum giapusento i investigasyon makikefutut makiketagam za megay na impedimento manmananai magi i komite. For the governor's office to obstruct these investigations by asserting absolute testimonial immunity on behalf of their employees who are not senior aides is bordering on a conspiracy to frustrate any investigation of himself. It makes the people wonder, what is there to hide? Man maapelaham ni tauto para baingwadok este na asunto. Za enno insetsegwi pogo. The governor's office asserts that senior officials of the executive branch have complete immunity from legislative subpoenas. They base this position entirely on internal memos of the Federal Department of Justice. But state and federal courts have taken the opposite position. There is no precedent in CNMI law on the issue of testimonial immunity for the executive branch. Malagos upago didide kwentus pud experience ko na matsoto zugi oficina ni gobyerno. Si Miss Frances de la Cruz umirensya ihagas posisyon no ni ho ocupa mas que 16 años. Gininiterminon Governor Larry I. Guerrero, Gobierno Furlan Tenorio, Gobierno Pedro P. Tenorio, hasta el último y terminon Juan en Babauta, 16 años na experiencia. Por todo este na experiencia ni hukakad ka, huwa segura todos hamzo ni man membro zani publiko na utungo claro hafa obligasyon niya edzo na posisyon. In that capacity, I know what the position entails and what is required to do, and none of those duties would entitle me, had I still been there, to the kind of obstruction that they are putting forth today. Ni nunca beses. A person subpoenaed or otherwise lawfully ordered to testify is required under criminal penalty to appear at the designated tribunal at the time commanded, take an oath or an affirmation to tell the truth and answer truthfully the questions put to him or her. If the witness refuses to obey the order to testify, he or she faces contempt proceedings. If he or she testifies falsely, he or she faces a charge of perjury. My colleagues and my people, we are here to strengthen and defend the rule of law, not to weaken it, not to attenuate it, and not to disfigure it. This is not a question of the perfection of law. It is, it is a question of democratic foundations and principles. That and nothing other than that is the issue before this House, before this committee. The personal fate of the governor is not the issue. The political fate of his party is not the issue. The governor is a trustee of our Commonwealth's finances and resources, and he has taken an oath to ensure that the laws of the Commonwealth be followed. And that is what the Constitution says, no matter what his defenders say. At this time, I would like to recognize Representative Vicente Camacho.
Thank you, Chair. Colleagues, it appears that this runaway government is full steam ahead. For a DC lawyer to appear in front of us and to invoke his defense at the local level is very telling, as I have stated before, that this governor will do whatever it takes to discredit, intimidate, and disrespect the people of the Sinamai. That this governor, with his connections to defend himself and his so called executive aide, is telling that their purpose of defense may be criminal in nature. Mr. Garber, who is not a registered attorney in the Sinamai bar, invokes his knowledge and experience against the people of the Sinamai is too disrespecting the people of the Sinamai. We should hold true with our purpose as a legislative body and take back our constitutional rights as one of the three branches of this government that rightfully belongs to the people of the Commonwealth of the Northern Mariana Islands, and to restore the checks and balances in our government, a government of the people, by the people, and for the people. Thank you.
Thank you, Representative Camacho. I would like to recognize Representative Donald Manglonia at this time.
Thank you, Madam Chair. I'll keep this brief to reserve time for Rep. Sablon. I just wanted to point out that, after listening to the Governor's Council, Mr. Garber, um, you know, the, this brings into question, where was all this argument when Ms. Rosario came in to testify? Ms. Rosario, who has whose role in the governor's office, deals with the processing, the documents coming in for the governor's review, and it all channels through her. And none of the councils have ever made this an issue, and they've allowed her to testify in front of the committee. Yet here, the committee is trying to bring in the governor's executive assistant to ask similar questions to what we've asked Ms. Rosario. And yet now they bring this issue up. Madam Chair and colleagues, we've heard from House Counsel Mr. Lade and Mr. Tyrone, and I think that, based on their arguments, none of what Mr. Garber had mentioned, you know, holds any teeth in regards to this legislative oversight. And so with that, Madam Chair, I think we should continue to hold that meeting with Ms. De La Cruz at the next earliest availability. And so with that, I stand ready to support your or the committee's decision in bringing her in with counsel. Thank you.
Thank you, Representative Mangonia. Is there anybody else who would like to make comments? Um, I now recognize Representative Tina Sablon.
Thank you very much, Madam Chair. I wanted to address a couple of issues that were my main takeaways from today's proceeding this morning. One is that the governor is invoking testimonial immunity for his employee who holds the title of executive assistant, but through his attorneys, the governor has cited no case law supporting this position. For the most part, we have heard citations from the governor's attorneys to internal memoranda for the Department of Justice, which has already been noted, have no controlling authority here, and which courts have disagreed with. The governor is not a king. His staff do not have absolute immunity. And it was apparent to us that the governor's attorneys had not actually seen Ms. De La Cruz's position description, and so could not actually justify their assertion today that she is a senior advisor or senior aide entitled, or high official in the executive branch entitled to any form of immunity, absolute or otherwise. She's not an attorney. There is nothing in her position description that's on file that indicates that she is a senior executive advisor. As the executive assistant of the governor, she schedules appointments, answers the phone, and coordinates his travel. We did ask the governor's attorneys to cite any case law that supports the proposition that a government employee in the executive branch whose duties are primarily administrative and secretarial in nature would be covered by testimonial immunity, and he could not today. As has already been noted, we have subpoenaed multiple witnesses thus far, including a member of the governor's cabinet, Special Assistant for Administration, Matilde Rosario. She testified. We have already subpoenaed the lieutenant governor himself. He testified. If the governor had invoked testimonial immunity or executive privilege on any of these witnesses thus far, could they have been barred from participating and cooperating with this lawful investigation? What are the limits of that power? And this brings me to the next point, which is that the governor, through his attorneys, has also raised questions about the legitimacy of this legislative investigation, and by extension, the legitimacy of our subpoenas. It is not up to the governor to decide what constitutes a legitimate legislative investigation, particularly when the investigation at hand is one that has been directed by the Speaker of this House, convened by the chair of this committee, and voted upon and approved by the duly elected members of this body. A fundamental function of the legislature is the conduct of investigations. Legislative oversight and investigation are our most basic responsibilities in this democratic system of government. And moreover, our subpoena powers, our investigative powers, are actually broader than the powers that are afforded at the federal level, because we have specific statutory authority in 1 CMC section 1301. And council has placed that on the monitor for all to read. And I'd like to read that into the record. Every investigating committee, when authorized by either house or both houses, as the case may be, may issue, by majority vote of all its members, subpoenas requiring the attendance of witnesses and subpoenas ducis tecum, requiring the production of books, documents, or other evidence in any matter pending before the committee. The public expenditures of the governor is the matter pending before this committee. The conduct of this governor is pending before this committee, and this is absolutely a legitimate purpose for investigation. Thank you, and I yield, Madam Chair.
Thank you, Representative Sablon. Is there anybody else who might like to make other comments in addition to that? If not, I would like the record to reflect that we will introduce the Garber letters, the two that were received by my office in the last couple of days, and all its attachments into record as part of these proceedings as exhibits. And also, before we close today, I do want to say that there is one thing that we agree with Mr. Ross Garber's statements is that we should resolve these issues in the House chamber and respect the legislative process. Um, and having said that, I would like to announce that the next committee meeting is scheduled for Tuesday next week on October 19th at 10:30 a.m. And we hope that no further barriers or obstacles are placed in our way so that we can receive the testimony of Ms. Frances de la Cruz, the executive assistant to the governor. At this time, can I get a motion to adjourn this meeting? Motion has been made and has been seconded to adjourn this meeting. Is there any discussion? All those in favor, please say aye. All those opposed, please say nay. The ayes have it. This meeting is hereby adjourned.